welcome to our third in the series, Closing the SEP Transparency Gap, how to gather patent pool and SEP litigation data to predict legal risks and royalty payments. So, as mentioned, this is the third in our series on the SEP data transparency gap. At the end of July, we had the program How to Deal with Data Accuracy Challenges. At the end of August, we looked at how to deal with SEP determination valuation challenges. And today we will be on a similar note, but looking at it from the point of view of royalty fees and litigation issues, important both for the licensee side and the licensor side. Today's speaker, Dr. Tim Pohlmann, is the CEO of IPlytics. He has done various doctorate work and other academic papers and studies at the Technical University of Berlin, Cerner, and Mines Paris Tech. He is again this year an IAM Strategist 300 recognized leader, and he has been involved in many economic reports written and put together for, amongst others, the EU Commission, WIPO, and the German government. He continues his hybrid existence beyond IPlytics as a faculty lecturer at various institutions, as you can see on this slide. And he is a regular author of industry articles for IAM magazine, IP Watchdog, and Managing IP, amongst others. So before we launch into today's webinar, just a little bit of housekeeping. If during this session a question comes to mind, you will see that there is a Q&A box at the bottom of the screen. Please feel free to write your comments there, and we will address those at the end of the session. So without further ado, let me pass on to my colleague, Dr. Tim Pohlmann. Thank you.
Thank you so much, Andrew, for the kind introduction, and welcome everyone to today's webinar part 3. I'm glad you're listening in. We do have a great agenda ahead of us. As Andrew already said, we will talk about the licensing, transaction, and litigation. And here we want to get started to talk about the people in our industry that deal with this every day, what their profile is, and what kind of data they use in their day-to-day to make and support their decision-making. We will then look at some data. We look at trends in licensing, transaction, and litigation. We will look at portfolio validity and essentiality, which is, of course, important and fundamental for any licensing activities. We will look at patent pools and what makes pools particular as a licensing venue. We will, of course, also look at bilateral licensing, to then look at how to use patent pool data to predict royalty payments when combined with other data sources that are publicly available, to understand potential licensing costs and burdens, aggregate royalties, risk, and plan that into your budgets. And of course, at the very end, we will discuss some takeaways of today's session. Let's talk about first the persona, the people in our industry that are active in the world of licensing. If you think about a company and how that company is structured, anything that has to do with IP, of course, starts where IP comes from, and that's the invention, the R&D teams. And the R&D teams typically work closely with the IP teams. There's typically a patent board, and that patent board would decide whether or not a new invention is actually worth patenting, because patenting is expensive. And it has to be sure that the patent either protects products, future products, or is fit for licensing. In the case of SEPs, is a standard essential patent. Once that is agreed upon and patents are filed and then eventually granted, those portfolios end up in the IP portfolio team and of course in the licensing team, where the licensing executives now have to make the decision which of the patents to be used for licensing. And of course also there we have different options. Bilateral licensing, meaning you set up your own licensing team and go out and approach licensees, or you join a patent pool and let the pool do the work. But of course, joining the pool also means you have to select your patents fit for pool that are included. And of course, you can also decide to give it all up to a third party and sell your patents and there monetize your portfolio. And typically most companies do all of these three options and these three different ways of monetizing IP. If you think about the evolution of a patent, also here, the licensing comes at the very end, at the lifetime of a patent, starting with a invention. In the world of standards, typically that invention is closely related to also input in the standardization process, coming in contributions, for example, that is then introduced into a standard and then eventually accepted. And once accepted, patent attorneys have to make sure that the claims read on the standard to have an essential patent. Only then, when the patent makes it into the portfolio is into internal analysis claim charted as an SEP, then the business development and licensing at the very end of the lifetime, or the lifetime cycle, of course, not before the patent is expired, but typically further to the end, the licensing picks it up and licenses it. What are the typical decisions licensing department has to make compared to, again, along the lifetime of a patent? This has to do typically with license target identification. A license manager must identify potential targets, meaning companies that implement a standard that are using the patented technology. But of course, they also have to do a due diligence of their own portfolio and see if it is fit and can survive challenges of validity or essentiality. You have to identify and maybe classify your patents as to certain technologies that you can then build a portfolio around to license that out. Of course, there has to be some claim charting for evidence. There has to be some landscaping and also analysis on risk. You always go out with a certain level of risk. And you, of course, have to then negotiate a license. So you have to make sure you have good arguments about your portfolio and what it's worth. Licensing executives can also be called portfolio development managers, business development managers, directors of corporate strategies, head of IP transactions. What they do is the main purpose is generating revenue from IP, which comes in different licensing activities, which includes both carrot and stick licensing. They typically, similar as in sales, have a pipeline of potential leads of licensees. They have to closely work with R&D and portfolio managers to identify patents that are strong enough to be licensed. They have to work with subject matter experts and legal experts to make sure to provide evidence of essentiality and prove that to a potential licensee. And of course, they have to have negotiation skills. And if a negotiation doesn't go anywhere, they also must have the needs and the means to litigate, because there is, of course, no way to provide or to apply any pressure on a licensee to take a license if you cannot litigate and enforce your patents. And all that, of course, also with monitoring competition to see who else is licensing in the field, what are their portfolios look like, what are the royalties they can ask for, those kind of things. The challenges and goals are, first of all, get started, finding assets in the portfolio that are fit for license, maybe also acquire assets to add to it to have a stronger case. Finding solid partnerships, like a patent pool. Maybe also you want to engage some third party to help you license your patent, or even sell the patents to a third party to do that. You want to hit the revenue targets and your pipeline, and you want to avoid any roadblocks. Typical use cases that need data support are strategic portfolio development, portfolio breakdown, portfolio valuation and comparison. Many of the companies also, especially when going to litigation, work with law firms. Also here we have different people that would care then about making sure a portfolio is licensed, coming from managing partners, partner attorneys, paralegals, research analysts that work on due diligence and providing evidence of the essentiality and validity of a patent portfolio. Let's take a look at some trends in licensing, transaction, and litigation around SEPs. There has been a study published, but there are several of those studies that looks into the world of SEPs. And what most of these studies identify is that, especially for new industries where we do not have any track record of successful licensing, we do see a lot of risk on both sides of the table. The licensor side has invested heavily in R&D, maintaining patent portfolios, and that side, of course, wants to monetize their patent, but it is unsure for which or of what kind of a royalty they can expect from their patent program, because there are not many data points on successful licensing in certain areas, let's say IoT. On the other hand, the licensee is in a similar position, implementing standards subject to SEPs without knowing how much they will end up paying, when they will end up paying. Are their competitors paying as well? Or will they end up paying first and having a competitive disadvantage compared to their competitors? There is a lot of risk, and the risk, of course, always of litigation is in there as well, which can be very expensive, but which also can have a PR effect on the company that they don't want. And that is unfortunately one part of this, and data can help to mitigate that risk in the market, and that's something that we will discuss later. If we think about the adoption of standards across the more typical industries, here's just an example of the Wi-Fi certification consortia, which basically lists all products that are using the different Wi-Fi generations up to Wi-Fi 6, which obviously most products are phones, followed by routers, which in the Wi-Fi space is also pretty straightforward, television setup boxes and computers, tablets, e-readers, but then it gets interesting: gaming, media, music, smart homes, and buildings. So we already see new industries here listed in the product categories where there is yet no SEP licensing in those areas, and where we have to foresee, or we will see, what's going to happen. We did actually conduct a survey, and we asked industry experts, and 54 of them answered, do you think that SEP licensing will be more challenging for IoT applications compared to the smartphone market? And indeed, 68% said yes, we believe it will be more challenging. Only 20 said no, we don't think so, and 11% said not sure. Another question we placed on the expert was, do we have to rethink FRAND framework for SEP licensing for IoT? And here, the answers are pretty split. 42% said yes, we need extended framework to make it work. 57% said no, we have a framework that should work the same, we have to figure it out. And 4% said not sure. It's pretty split. So, you know, it's unsure if FRAND will work, but I think the majority still believes in general we have a framework, we have to apply it to different industries differently, but it works. If you look at litigation trends, so basically we looked at all patents declared that have been cited in a litigation, we do see that the later generations are up and coming, increasingly pushing for litigation. Obviously, with the more products on the market that are compliant to the latest standard generations, we also see more litigation in the space for that technology, heavily pushed, of course, by cellular technology, but we also see wireless technology and video coding and audio coding technology among the litigation cases. Of course, there was a big wave to be mentioned that was I would say 1 year ago, or ended 1 year ago, where the automotive industry suddenly was approached by patent platforms like Avanci to license. And the Avanci members heavily litigated against the automotive OEMs, which you can see here led to a lot of litigation cases across the world, Germany, Japan, US, you name it, everywhere. And big OEMs, big brands like Daimler, Tesla, Ford, Honda, Volkswagen, Toyota, General Motors were all in litigation cases to be pushed to agree to a license of cellular technology patents. What is also interesting that we have seen a trend that courts have started to actually provide some information on global rate setting. And we did see and observe that in the UK in particular. We even haven't listed all cases here. Of course, there's a famous case of Lenovo in there that was in the Interdigital that was published, US and China. Interestingly, the courts always ask the parties, should we set a global rate, or not set, but you know, should the court get involved in setting that global rate? And in not all cases the parties said yes, but in many cases they did say yes. The problem with global rate setting, of course, is that a local court, because obviously you can only force patents where the patent is valid. So in the UK, you can only go there with a UK patent. So actually a UK court can only decide on the validity or infringement of a UK patent. Now that they make a decision on a global rate is of course something that in general, in the whole structure of sovereignty of local courts is questionable in a way that, you know, how can that one UK court now set a rate also that should be valid in other countries? And that indeed led to some confusion and even more to anti-suit and anti-suit injunctions. Disputes that we observed and luckily have been slowing down in the past 2 years, but before that we did see that a lot. And quite interestingly, we looked at the anti-suit injunctions and the courts it came from, and most of the anti-suit injunctions came from the US, 64%, followed by China, 29%, in the UK. Well, then the anti-suit injunctions, however, they came mostly from Europe, 50% from Germany, followed by the UK, 10%, 10% France, 10% Netherlands. So anti-suit injunctions, US, China, and then anti-suit injunctions came more from Europe. That is quite interesting to observe. Luckily, as I said, the data shows that has been slowing down. Anti-suit injunctions didn't help many people or helped anyone in rate setting. It creates, of course, a lot of confusion in the market. In general, if you look at SEPs and litigation, we do see that patents that are declared are litigated much more often. And this is US data, that's the limitation here, but still it gives you some trends. Data shows that declared SEPs are 3 times more likely to be litigated than other patents from the same technology. A declared SEP had a chance of 2.2% to be litigated in the US, right? So if you have 100 SEPs, it is very likely that 2.27 of those are going to be subject to litigation, which is a pretty high percentage. If you think about a different data approach, if you think about this, the cases, are cases more likely to be featured by an SEP, again, US cases here, and yes, a litigation case in general is 4 times more likely to be featured by a declared SEPs. Of all US litigation cases, 2.06% featured at least one declared SEP, right? So out of 100 US litigation cases, 2 of the cases were featuring an SEP, compared to the data above. Out of 100 SEPs, 2 of those SEPs were, or even more than 2, were subject to litigation. So depending on your view or approach of the data, this is all pretty high, and it shows that SEPs are just in nature that they are infringing automatically when a standard is implemented. By that nature, they are more likely to be subject to litigation. Why is that interesting, and why should you monitor that? At IPlytics, we believe that monitoring litigation is super important for your teams, especially the legal teams, to understand what's going on in your market. For example, if you are tracking in your industry, has there been litigation and who litigates against whom, it helps you to really kind of estimate am I going to be the next defendant in that litigation? Because my competitor in the very same market right now is subject to litigation. What are the standards typically subject to litigation? Do I implement those standards in my products so I am potentially exposed to litigation? What are the trends here? And of course, in which territories and regions are litigation coming up? Is it mostly litigation, let's say, in Germany, where my products are not even sold? Or is it also litigation in China yet, where I have my production facilities? All those questions are super important to answer, and data can be an answer here in that case. The next topic I would like to talk about is validity and essentiality, and in particular, put some focus on validity. Because if you set up a license program, your patents must not only be essential, your patents will always, in most of the cases, also be challenged in terms of validity. Is there any prior art that shows your patents are not valid and therefore, at risk? Again, going back to the goals of a licensing executive is to properly manage a SEP portfolio, which should generate revenue. And of course, balance the investments that you have made to get there. The R&D cost, the maintenance of the patent at the patent office, the whole management of the portfolio, and sometimes even acquiring additional patents to make your portfolio fit for license. That is, of course, risky. You have to make very critical decisions when to invest in R&D, standards development, patent prosecution, etc., etc. And the risks are there because even if you manage to file your patent that gets granted, it is yet unsure if your claims really read on the final standard, if all elements can be identified and mapped to the standard, and that your patent is valid and not, invalid. So it is fit for cross-licensing, out-licensing, or joining a patent pool. We looked at the risk. We did a statistical likelihood analysis on a scenario analysis. And the way it works is you look at scenarios. Validity, we looked at a pessimistic scenario, meaning out of your portfolio, only 30% will be valid. Everything else will be invalid. And we looked at an optimistic scenario where 80% of your patents will end up being valid. We did the same for essentiality. That's the second line here in this table. Low essentiality, 10%, medium, 25%, high, 50%. And now look at the portfolio size. And what you see is, in a pessimistic scenario, you do need at least 250 patents in the portfolio to make sure you have at least one patent that is both valid and essential, right? So if on average your patents are 30% only valid and 10% essential, you need 250 patents to make sure you have one. Your one patent is maybe enough, one patent, one bullet kills, we say. But that shows that your portfolio has to have a certain size. And even if you assume like some medium, not so pessimistic scenarios, like 25% essentiality rate and a more optimistic validity rate, you do see that you also here need at least 50 or up to 100 patents to make sure you have something in your portfolio that really is strong enough and has enough patents, or at least one essential patent, to go and enforce your rights. Validity is not given. The immense amount of potential prior art documents create for anyone, a potential risk of losing your patents. Why is that so? Because in prosecution, very often, patent offices may not have all the information at hand, and your claims may be well drafted, but maybe a little bit too broad, so that they touch prior art. In fact, give you some statistics, 76% of all IPRs filed against SEPs used so-called non-patent literature as prior art. 66% of these proceedings specifically use non-patent literature produced explicitly for the purpose of developing a standard, which includes technical specifications, technical contributions, reports, working group documents, anything, all the documents that are produced in the standards development. You can imagine that people go into those meetings produce a lot of documents, and it's all publicly available, which makes it subject to be a prior art document. When each and every contributing company, basically uploads a longer contribution describing the technology that they would like to include into the standard. But also, again, meeting minutes can be part of it, or even the final standards. If you look at prior art citations in patents, we do see indeed most cited documents are standard contributions. Almost 50% of all the declared SEPs cite those, followed by actual technical specification, meeting minutes, and technical report. The offices, or the patent offices, have realized that, in fact, and they all signed so-called Memorandum of Understanding, USPTO in particular, and the EPO, but I think also many of the Asian offices followed up here, so that they get access to documents from ETSI and IEEE, including the drafts of standards, temporary drafting, contribution, working group minutes, all that. However, formally, as to my knowledge, only the European Patent Office has, since 2006, created a proper database that every examiner of every patent that is, applied for can search in full text through those documents, making sure they find anything that may be subject to prior art. And that shock, that change of policy that the EPO has given their examiners access, that was compared to the USPTO. And indeed, what we see here on the left and the right side is the standard related patent filings and the rate at which the patent was accepted and granted at the USPTO and EPO. And on the other side, on the right side, patents that are non-standard related. And we see for non-standard related patents, USPTO and EPO behave very similar. But on the left side, where it's about SEPs, the behavior was similar before. So USPTO rate of acceptance of patents and EPO was always a little lower, but the EPO rate really decreases after examiners got access to the prior art documents from the standards development, while USPTO remains at the same pace, showing that, at least to this analysis, the number of the quality of the patents probably increased at the EPO because the rate of acceptance decreased. They found a lot of prior art and said, no, that's not an invention. That's not a new novel invention that you're submitting here. While at the USPTO, they didn't do that. So there's some evidence here that access to that data also increases the quality of the SEPs. One way for many licensees is really when they get approached by licensors, especially when they have a smaller portfolio, is really fighting validity. That's a very effective way to get rid of patents that they don't want to pay for, or at least pay less, right? And the number of implementers have started disputes, and especially in the US, where you can file an IPR, an inter-parties review, it is a very strong defense against the licensor. We do have also here some statistics of IPRs in the USPTO and the so-called PTAB, showing in how many cases of SEP's proceedings compared to other patents, all claims were canceled. You see that in the first column here, 78% of all claims were canceled for SEPs compared to normal or other patents in the same area. Some claims canceled, no claims canceled, and total number of claims. So, the statistics also show, especially for SEPs, lots of claims get destroyed with PTAB and IPR, which shows that this is really a high risk for any SEP holder. How can you work against that? What are ways and approaches to make sure your patents remain essential and valid? You can, of course, do that manually, and that's what most companies do. They have their inventors to communicate with the patent attorney and early on in the process, and they make sure that all the documents are handed to the patent attorney so that they claim the drafts or draft the claims in ways that are essential and valid. We work with more and more companies on providing both experts here, either the inventor team, but also in particular the prosecutors and the patent attorneys, with fully indexed standards contribution data. At IPlytics, we do gather every week all the documents at the different meetings, for example, at the 3GPP, IEEE, different video coding consortia like JVAD and others for HEVC and VVC, to track each and every document and allow them to search through those documents in full text. And that helps them to identify early on the documents that they consider when claim drafting, even after application, making sure, you know, they constantly claim chart their patents to be close to the standard, but making sure they also remain valid and not subject to any prior art that we can identify through the data. And there are different ways to search for it. It doesn't have to be always full text. It can also be following certain meetings and proceedings. It can be following certain inventors that are listed as authors on the contribution that you know might be of relevance. And of course, you can search all of that in full text. The next topic that I want to touch upon is the different ways of licensing, and here looking first at joint licensing platforms, patent pools. Patent pool is, in economic terms, when aggregated all patents in one-stop shop, right? That's more like a theoretical thing, but we currently do see with Avanci that Avanci's new 5G program for the automotive space gets closer to be a one-stop shop with a very high percentage of coverage. Economists typically see patent pools as very positive. First of all, it does reduce transaction costs. It's straightforward. If I include patents of 100 patent owners, all you need is one contract and not 100 contracts that you would otherwise need when you would license bilaterally with all the 100. Another economic effect is the double marginalization. The 100 licensors may overestimate the value of their patents beyond what there really is. If they come together and, you know, set up a contract all together, it's very transparent. Everyone knows the share of how much they own, and they can come up with the price, which then has to be fair and reasonable. If companies do that individually, uncoordinated, not knowing what their competitor's price is, they typically ask of a too high price on average, which we call double marginalization. So that would create a too high stack of royalties for the implementer. Obviously, pools can clear blocking positions and in a collective facilitate the use also of the technology, which is typically a good thing. However, pools come with certain rules. You know that every pool has to be optional, meaning any licensee must have the potential also to go still to the licensors individually. So a pool is or must always be an option. It must be allowed to also still license outside of the pool. Plus, a pool can only include essential patents. You're not allowed to bundle in any other patents that are not essential and necessarily used to implement the standard. That bundling would also be against anti-competitive rules. Pools, however, even if followed all the rules, come also with costs. First of all, setup costs. You have to find agreement and alignment among all the major SEP holders, which is very difficult and somehow a chicken and egg problem, because typically those companies are competitors and they may not want to join a pool if their competitor is not joining and stays outside of the pool. So seeing that they may have an advantage with that. Very difficult is also setting the right revenue sharing rule. I said that earlier, companies have to come together and then they have to value their portfolios against each other and kind of decide, you get 10% of the cake while I get only 5% of the cake. How do we identify that? Simple patent counting may not be enough. How do we value in your portfolio? And how can you give me evidence that your portfolio is of higher value than mine, or the other way around? That, of course, may create negotiations and complexity. And of course, then you need to set up a rate that is accepted by the market, meaning the licensees. If licensees do not want to take the rate, you have to think about consequences. Pools typically do not enforce patents, so members of the pools have to go individually to enforce those patents. And that, of course, is something they also may want to do individually. and not in agreement with the other pool members. And there may be situations where not all pool members are in agreement to the activities or the aggressive approaches of other members. And there may also here be, missing alignment on that. Again, looking at pools, you can look at the shares of what the pools cover. And again, we looked at that for several pools. One recent example is the Avanci Vehicle 5G multimode pool, which is basically a pool that includes 2G, 3G, 4G, and 5G V2X, all cellular technology into one pool program, and offers that only to the automotive industry right now for $29, and in half a year's time for $32. Counting patents that are declared and at least granted in one of the IP5 jurisdictions, US, EP, China, Korea, Japan, this pool, Avanci Automotive 5G pool, it is actually 5G multimode, so it includes 4G, 3G, 2G, has 80%, over 80% of all patents included. If you are a bit more conservative and say, I want only count families that at least have been granted also in the US and Europe, then it's 83% even. And if you weight in a value index, we call the patent asset index, meaning you give more value patents a higher weight, the pool even covers 85%. So a pretty good coverage of the pool, including most of the patents. There are many successful pools, or have been also many successful pools in the past. And I think the success is best shown when you look at the number of licensees. The video codec pool AVC has 1,500 licensees, which is a lot. It's really the whole industry is licensing to it. MPEG Audio, over 1,000 licensees. Advanced Audio Coding, 890. MPEG 2, over 822. So a lot of success in the audio video coding across so many different industry players. However, we also have complexities with pools. Some technologies not have one pool. HVC, for example, has 3 pools. And that also means you have to take a license from 3 different pools. And VVC, the latest generation of video coding, we also have 2 pools. Let's talk about also how bilateral licensing typically works and what are the reference points used when negotiating a license. Again, we work here with survey data, and we asked industry experts, in this case 182 experts, what is your experience, the more accurate approach to determine FRAND? And most of them, over 60%, over 2/3, or exactly 2/3, said it's the comparable license approach. 20%, none of the above. 13%, the top-down approach. A big challenge, of course, always with the comparable license approach is you need a comparable license, which you may not always have, or which may also be not available because those are under non-disclosure. And that is a big issue in the industry. Typically, both licensor and licensees have their own data, but they cannot share the data in a negotiation. Second question we asked, what is, in your opinion, the best way for companies to decide on the value of SEP portfolios? And most of them agreed, well, that should be done in a bilateral negotiation. While 12% said imposed by regulation, 7% said imposed by judge, 6% legal action, and then threats. So the majority agrees, yes, it has to be done by in the negotiation phase. Do you think there should be more or less transparency by companies licensing SEPs around the structure and the pricing of the completed deals? And yes, the majority argued we would love to have more transparency, which is, again, a very tricky thing because all of these deals are under non-disclosure. And for good reasons. Those deals include very sensitive data on very exact numbers of how many products are sold over time in which markets that they don't want in the hands of their competition. Right? So there are good reasons on the licensee side and licensor side to keep that undisclosed. Now, I would like to now present to you what you can do with publicly available data and a data source like IPlytics to make cents of publicly known royalties and compare them with privately offered licenses that you as a licensee get from a licensor, or that you as a licensor can compare your offering with. Imagine a company is implementing standardized technologies in the video world, let's say a TV that is compatible with VVC technology. And that company eventually gets a letter. And typically the letter, the way it looks like, it says, you know, you are using the VVC standard in your products and you're compliant and you have to pay royalties. And let's say that letter comes from a patent pool. And the patent pool requests from you 70%. And that actually is a real case. We aggregated here even the two pools. So for VVC, we currently have Access Advance, 50 cents per device, and VLA with 20 cents per device, which in some, you know, if you would take a license from both VVC pools, would be 70%, 70 cents. So what you know now in the landscape of VVC is, well, if I license to the patent pools, I pay 70 cents per device, right? That's known, right? That's on the websites of the pools. There's no negotiation. It's non-discriminatory, so I cannot negotiate this one further. I have to pay the 70 cents, right? What I do not know is who else owns SEPs on VVC. And may there be companies I do not have on the radar that may also approach me to get a royalty. So what is actually the aggregate royalty? What will I end up paying at the end of the day when the patent owners beyond the patent pools ask for a license? In order to calculate that, I will need the share of the pools, right? How much of the VVC patents do the pools actually cover? And those questions can be answered with data. Because in the end, if you think about the share of a patent owner is basically the portfolio, in this case, the portfolio of a patent pool of VVC SEPs compared to all SEPs that exist for VVC. If you look at the IPlytics data, you can make a selection and say, I want to search for the standard generation VVC in a certain time range. Typically in licensing, you have products in the market since a certain time. So you can basically set a range of time that limits that to when new products were sold. And of course, limit to certain jurisdictions, territories and regions where you sell your product. And if you do that, and if you search for all the VVC patents in the world, we can aggregate and add together all the patents that we find in the VLA pool. And there is an open list on VLA's website where you can see members of the pool. And if we aggregate the portfolio of those members, we identify the VLA pool gathers 3% of all VVC patents. We do the very same for Access Advance. Look at their members: Tencent, Etri, Panasonic, Sun Patent Trust, YouTube, Dolby, and add them all together, and we get 19% of all VVC patents for this particular pool. Again, the members are publicly available on the website of the Access Advanced pool. All we do is we leverage the IPlytics data to gather the share of all these portfolios and add them together. So, to summarize, VLA and Access Advanced combined offer VVC SEPs for together a sum of 70 cents per unit. The share of patents they gather together excuse me, is at 22%. Now we can use very simple math, taking 100 divided by the 22 times the 70 cents, which shows me that when I'm assuming everyone asked for the same price as the two pools asked for, I have to pay in total $3.18 to have all VVC patents licensed in, right? And that is the aggregate royalty I can work with now. This is a number, a dollar value that I can put in my books, that I can plan in as a tax to my selling my products, if you may want to call it that way, and understand that I add this price to my devices that I sell. Even more, if someone approaches you now, you can tell that someone, hey, how much do you offer your patents for? And if these are VVC patents, you can actually calculate and see if that is a comparable license, meaning what they ask per patent is similar to what the pools ask per patent, because you have the reference points. And you're expecting not to pay more than an extra $2.48 beyond the pool license. And if someone comes along who owns 10% of the VVC patents, but offers them at, let's say, 80 cents, you could say, well, that is excessive. I am expecting they only cost 30 cents based on the reference points I get through the patent pools. So data helps you to compare any offer that you receive with reference points in the market. And a pool is always a great reference point because it's a public price on a public website that you can point your finger to and say, it's not under NDA. And I know through the data from IPlytics, the share of patents they own, please, be advised that your offering is excessive. And I have evidence for that. We can do that for other standards too, 2G, 3G, 4G, 5G, but we do not always have pool reference points. In some cases, and I want to look at 5G here, we have, however, public announcements of royalty caps. A royalty cap is basically when a company publicly announces that they will license their patents to a royalty not higher than a certain amount. Qualcomm did that in a press release. They said $13 is my royalty cap for multi-mode 5G devices, chips. InterDigital said $1.20, Nokia said $3, Huawei said $2.50, Ericsson said in some situations we will ask for $5, in others for $2.50. And then we have one reference point. It's a small one, and that's why I put it down here. The Sysvel pool with a very small number of patents, but still they asked 50 cents for what they own. Of course, it very heavily depends on the size of the portfolio, whether or not these dollar amounts are reasonable or not. What I know from Sysvel is Sysvel asked 50 cents for their share. But now I have to calculate the Sysvel share to understand the aggregate royalty that I can expect. And again, we use IPlytics platform. We search through all the 3G, 4G, 5G declared patents, look at granted patents only, set certain filters, and identify the share, again, by dividing the portfolio, in this case, the Sysvel pool, by the aggregate market number of patents in the market to get the share. And for Sysvel, at the very bottom, we find that they own just above 1% of all the 3G, 4G, 5G declared and granted patents at the 50 cents, right? Qualcomm owns 12%, Huawei 14%, Nokia 7%, Ericsson 5%, InterDigital almost 2%. Now, with that percentages and market share, we can calculate from the price of each individual announcement of the royalty cap what aggregate royalty we may expect. And we do see big differences. Qualcomm has a very high price point, right? If we follow the Qualcomm pricing, you would pay in total $100 for 5G multimode. If you would follow the higher level Ericsson pricing, $92. The average across all the announcements and the Sysvel pool is actually at $58. And Sysvel, as a pool reference, is at $45. And again, I would say a pool is the best reference point because it's a real world license price that is on a public website and that is actually used. Of course, the press releases of the companies are announcement. It doesn't say that they really use the price in licensing. And you see with the black or the grayish bar, the difference of what is publicly announced to Sysvel as a reference point. And we do see that actually the lower part of Ericsson basically hits exactly what Sysvel is asking for. Some have even lower ones like Nokia and in particular Huawei. They're very reasonable licensing rates that they announce compared with that is not the case with the higher level of Ericsson or the higher level of Qualcomm. Obviously, you can now argue that the data of IPlytics also needs to factor in the value differences of the different portfolios. And that, of course, is also possible. IPlytics may be only one data point. You can add other data points and recalculate that. That's all possible, of course. So we don't want to be the one truth of defining the share of a portfolio of a company, but it's one way to look at it. And it's a very interesting one, again, to negotiate a license and compare what is offered to reference points in the market. So again, important is that the data allows you to be flexible, limiting the data to jurisdictions. Not always you are negotiating a global rate, or you want to weight in certain jurisdictions differently. You want to care about different releases. Your products may only implement not the latest release, but only up until release 15. You may want to factor in IoT certain protocols that are limiting, again, the data to NB-IoT and LTE-M. All that is possible with the IPlytics data, so it really allows you to break down the data as specific as possible to calculate the shares. And that allows you, and that gives you reference points to identify what is offered here as a license. Is that excessive? If you're a licensor, what price can I ask? Do we have reference points in the market? What is my competition doing? Comparing that with the IPlytics data allows you to see, you know, the Ericssons, the Qualcomms, etc., what they ask for, and if that makes sense to you. And that is also why IPlytics platform has been used by the licensing executives in FRAND negotiations, in more in-depth analysis of portfolio and identifying whether or not a royalty is excessive or not. Identifying and understanding and providing third-party objective data that is not subjective. You can always argue how accurate it is, but it is subjective. It's objective data point that can be used to identify and compare comparable license agreements, especially if you as a licensee or licensor have your own internal data that you can apply it. What are the takeaways of today's webinar? I think for licensors that are active in licensing, it's clear that with data, they have a much better understanding of how they want to go out in the market. IPlytics allows them to identify the patents that are fit for purpose to license. As you know, we have different metrics on valuation. We can identify patents that are undeclared for VVC and Wi-Fi and the G standard, for example. We help them to sort and identify a portfolio that they can build and then maintain and go out and build a licensing program around. We help them to identify all the pools in the market that they may want to join and not go by themselves. We help them to see litigation trends of their competition. We help them to see transaction trends if portfolios have been sold to others, to also see selling patents as an option. And if so, who are parties that currently are acquiring SEPs? That very much helps. Reference points and allowing to compare these reference points help in cross-licensing agreements, help in price determination, in identification, and help to build and to maintain a patent portfolio. For licensees, even more, we provide a lot of transparency. We provide transparency on who owns how many patents for which technology, and is the royalty that is offered to me a FRAND royalty, or is it excessive? And I can provide evidence that the royalty is excessive by showing that certain patent pools ask for a much lower rate than what is offered here at stake. Or I can compare it to deals that I already signed, compare that with the IPlytics data to get the size of the portfolio differences in the calculation right, and then go back to the offer of the licensor and say, I have signed deals in the industry with your peers that actually have similar portfolios, but ask for a much lower royalty. I am able to break down the data and look into particular use cases. I may not use the full potential of 4G and 5G when I am the producer of a tracker device or a smart meter device. I may only use NB-IoT protocols or LTE-M protocols that are subject to much less patents and where the portfolio sizes are also very different. All that is possible with data, and it helps you here to support your decision making. If you have any more questions on our data, or if you are interested in anything that I just showed you here on the slides, do not hesitate to contact us. Our experts are trained for you to take your case, your particular use case, walk you through it, and see if the data can indeed answer questions that you cannot answer today. So do not hesitate, book your appointment. Also, I want to make you aware of our podcast where I discuss with industry experts very interesting topics all around SEP licensing. I have a lot of licensing executives on my SEP couch, from patent pools, from bilateral license negotiations, licensors, as well as licensees. All the experts have been on my couch, so listen in to the latest episodes on the SEP Couch podcast that is available across all channels and on YouTube. And now, Andrew, we have 5 minutes left for a few questions from the audience.
Thank you very much, Tim. First question. You started off the presentation looking at litigation results of active SEPs in the United States. And you said that 2.27% of SEPs ended up in litigation. Lying behind that, I suppose you can't really say because you don't know, but how much legal threats lie behind the scenes that never actually reach a legal court, but in turn could impact the uncertainty in the marketplace and actually impact the marketplace in terms of such negotiations to come? I realize it might be only a guesstimate, so to say, but would you like to comment?
I mean, litigation, and I think that's known in the industry, is the tip of the iceberg. If you look at 100 SEPs, and if you look at the owners, and these are major owners, I can tell you 100% of these SEPs are licensed, right? So if you are implementing a standard, they will approach you. They will send you a nice letter. And if you don't respond to that letter nicely as well, you know, it starts when it gets more tricky and where you will be put under some pressure, at least, to pay a license. I think to apply pressure to make someone pay a license only always works with the potential of enforcement. It's basically, you know, I cannot make you do anything if I don't have leverage over you. And that leverage shouldn't be too high. It's not my opinion that everyone should immediately get an injunction. But I think licensors must have the means, if worse come to worse, to go up into courts and litigate. And that has been, especially in the recent years, been a very exciting road. We have seen litigation not only in the typical jurisdictions that we used to in the US and Europe. We've seen litigation in Brazil very effectively because the Brazilian market, especially in smartphones, is pretty significant. Seen that even in Colombia. And the latest developments even show an increasing number in India, the now largest market of the world, where in the case, for example, of Oppo withdrew from Germany, a huge market, but they said, no, I'm not going to sell Oppo phones anymore. I go and leave Germany. But now Nokia has them in India, and very likely they cannot leave India. It's the largest market for Oppo after China. And we do see more venues, international venues, that allow these companies to litigate and enforce. And I think a certain threat, right? A certain threat doesn't have to be a monopoly threat that pushes people into paying higher prices. That would be also wrong. But a certain threat is always there. And if it's not there, you have no leverage at all to request a license, because then as a licensee, I would wait and see. And if you can wait and see, and that is an option, and no one can fight you and no one can go after you, that's exactly the strategy that others will follow, right? And I think also from the perspective of willing licensees that have paid the license, I would want everyone to pay the license. I don't want that our competitors can do the wait and see strategy. So I want them to pay as well. So a certain threat must be there for the system to work. Again, litigation, tip of the iceberg, but the tip of the iceberg, if 2 out of 100 patents are litigated, is a pretty substantial tip. So I think litigation is a very realistic scenario if on the other side of the table you have someone very actively licensing. That makes sense.
Thank you, Tim. The other thing is, coming to examples of how you can benchmark royalty rates, in which you use Siswell as a pool to then show you how you could go through various cellular royalty rates. How can you actually, when you did your analysis, you showed enormous differences between the various companies. Now, of course, you can use as the benchmark the actual market shares of SEPs. But then, of course, there is another issue about the essentiality of the SEPs that could make a difference and might be an explanation for why the figures vary so much, sometimes to the degree of 2 or 3 times in differences in pricing. That adds an extra layer of complexity when looking at this. Could you comment on that, Tim?
Yes, and I think it's really important to say that IPlytics is not the truth on defining the percentages of portfolios, but it's a data point, it's a reference point. Most of our clients have also other data points. Also the implementers, they have claim charts from portfolios of the companies that have requested a license. And with those claim charts, they can somehow estimate the essentiality rate of those portfolios. We also at IPlytics have claim chart samples, random samples that can be a reference point that can be used. IPlytics also has something that we call the semantic essentiality score. It's not a claim chart. It cannot be confused by a claim chart either. It doesn't have the quality yet, but it's one way to filter out and get closer to the truth. So we can set a certain threshold of the likelihood of a claim to be reading on a standard, which will reduce the data to be less noisy and have less over declaration. Again, not going to show only essential patents, but at least show more essential patents in the data set. And other evaluation matrices that can be used with data are also available. And those are some ways, again, that allow you to create further data points that allow you to explain maybe the Qualcomm portfolio is double the value, and that's why they ask double the price. But, you know, I think data is objective and it is worth having those data points is part of it. And if there are other evidences of saying we have evidence that our portfolio is twice as valuable than others or twice as essential than others, we can factor that in, right? Mathematically, that's easy. But getting the data and starting somewhere is, I think, what's the importance is of a software and solution like IPlytics.
Okay. Once again, thank you, Tim. And I would also like to thank all our viewers this afternoon from Asia Pacific and in other parts of the world if it's either morning or in the middle of the night. And finally, I'd also like to say that the recording of the webinar today and the previous 2 webinars that we've had in this SEP Transparency series can be accessed via our website or by making contact with your IPlytics account manager or contact. So without further ado, I would just pass back to Tim. Thank you.
Thank you. I have not much to add, Andrew. Thanks for the great moderation. Thanks for everyone to listen in. Stay tuned with further events and webinars, and I hope to see you soon. Take care and have a great day. Bye.